جدا. الاتجاهات الحديثة في قواعد مراكز التحكيم هو عنوان الجلسة الثالثة، والتي يسرني دعوة رئيسها الأستاذ فيصل راشد السحوتي، الرئيس التنفيذي لمحكمة قطر الدولية ومركز تسوية المنازعات، فليتفضل السادة المتحدثين إلى المنصة مشكورين.
بسم الله الرحمن الرحيم، والصلاة والسلام على أشرف المرسلين نبينا محمد وعلى آله وصحبه أجمعين. الحضور الكريم، السلام عليكم ورحمة الله وبركاته. بداية أود أن أتوجه بالشكر الجزيل إلى غرفة تجارة وصناعة قطر ومركز قطر الدولي للتوفيق والتحكيم وجميع القائمين على تنظيم هذا المؤتمر. كما يسرني أن نرحب بكم في الجلسة الثالثة من أعمال المؤتمر العلمي الرابع للتحكيم الدولي بعنوان الاتجاهات الحديثة في قواعد التحكيم. لقد قامت العديد من مراكز ومؤسسات التحكيم الوطنية والإقليمية والدولية بمراجعة قواعدها التحكيمية في الفترة الماضية، لا سيما بعد انتشار جائحة كورونا، حيث حرصت تلك المراكز والمؤسسات على تحديث قواعدها وفقاً لأفضل الممارسات الدولية، وذلك لتعزيز فاعلية ومرونة إجراءات تسوية المنازعات، وبما يسمح بالاستخدام الأمثل لوسائل الاتصال الحديث. واليوم يسرنا أن نرحب بكوكبة متميزة من المستشارين والخبراء القانونيين في مجال التحكيم لإلقاء الضوء على آخر المستجدات والاتجاهات الحديثة في قواعد مراكز التحكيم. وبداية دعوني أرحب بضيوف المشاركين في هذه الجلسة، وسوف نبدأ مع الدكتور جورج أفاقي، أستاذ القانون بجامعة باريس الثانية، والذي سوف يلقي الضوء على قواعد غرفة التجارة الدولية ICC لعام 2022. فليتفضل مشكور.
Thank you, Mr. Chairman. Good afternoon, everyone. Ladies and gentlemen, I would like to join the chairman in expressing my deep gratitude to the organizers for making me part of this wonderful event. It has been an incessant sharing of knowledge and expertise since this morning, and I will try to follow that path. Now, it may look odd to some of you to say, well, here's Professor Affaki, who is purporting to express his thanks to the organizers by talking about a competing organization, speaking about the ICC rules. Well, that objection could be admissible anywhere other than before QICCA. QICCA has always had an inspired leadership, a leadership striving for excellence and looking for the best practice wherever they are. And it seems to me, after what I have heard this morning from Mr. Al-Garhi about the new rules, that it should be ICC who should come and learn from QICCA about the latest best practice in arbitration. I should also start with another preliminary point, which is until last year, when I was asked to present the ICC rules, I would usually use the nominative pronoun I or we. I was until June a member of the ICC court, sitting with my colleague, Dr. Thani Ben Ali, as members of the ICC court. Since then, and after finishing my 2 terms at the court, I stood down, as is the tradition of the court, which means that I am able now to share with you my insight, having shepherded the ICC Rules 2021 to adoption and implementation, and having the advantage of being able to speak on my own behalf, which is always a relief. Now, this revision that I would like to share with you, the revision that was adopted in December 2020 of the ICC arbitration rules and came into effect on the 1st of January 2021. Of course, the chairman reference to 2022 is not an error, because the idea is for me to address the implementation of the ICC rules as we stand in 2022, but the rules are known as the 2021 rules. This is the 9th revision of the ICC arbitration rules since the inception. And the inception, ladies and gentlemen, is 100 years ago. And whenever you have a revision of the ICC rules, it is an event of planetary dimensions. Thousands of comments pour from all over the world, from over 95 countries, members of the ICC, and all the law firms, other arbitral institutions, international organizations who are interested in international arbitration. And to give you an idea about the figures in ICC, imagine an organization which has each year roughly an average of 900 new cases. It goes up and down, but that's roughly the average. The average amount, $184 million. And you have also parties from over 143 countries. The first Arab country is the UAE in terms of the use of ICC rules and ICC arbitration. And each of the revisions, and there have been 3 revisions to the ICC rules over the past decade, should better have a very good reason to be started, given the effort that goes into a revision, not only in terms of having to look into thousands of comments, as I indicated, but hundreds of hours of education in law firms, in companies, updating procedures, and what have you. So if we look back, and I will take arbitrarily the last 3 revisions, the one of 2012, and maybe I should indicate that there's always a common thread across the revisions, which is how can the rules and the application of the rules be more time and cost efficient? And how can the ICC be more transparent? So this is the leading thread that you will have throughout the revisions. But then in particular, if we were to focus on the revision of 2012, It is known for being the revision that brought emergency arbitration into the rules, and it has been an unfettered success. It is also the revision that brought rules for complex arbitration, multi-party, multi-contract arbitration. 2017 is the revision that brought expedited procedure into the ICC rules. So you have the traditional ICC procedure, and anyone who has lived through an ICC procedure knows the main milestones. You start with the case management conference, then the terms of reference, and then the pleadings, et cetera, et cetera. And the question that arose is, at a time when everybody was complaining about too much time, too much cost, was there something that could be done to have a better cost-efficient, a better time-efficient procedure? And the idea was considered and ultimately adopted to have expedited procedure for proceedings where the amount in dispute does not exceed then $2,000, with the possibility to opt in for disputes of a higher amount where the parties choose to have the expedited proceedings. Now, the expedited procedure is usually done by a single arbitrator, not three. So when you have to look at the agenda of one arbitrator, it is always easier. It is also less costly. And you don't have to go through the terms of reference. And the case management conference will take place 15 days after the inception of the arbitration, et cetera, et cetera. And this has been a tremendous success, which is one of the reasons why in the revision of which I'm about to share with you some highlights in a minute, that amount, the $2 million, was increased to $3 million, because we're having increasingly cases with much higher amounts opting in the expedited rules. And of course, the new revision that I will share with you now can cover easily a week of discussion. This is the time that it takes me to cover it with my students. I suspect that the generosity of the chairman would not extend to cover 1 week of me standing in front of you to cover all of that. So I will arbitrarily choose to address 5 themes: technology, complex arbitration, efficiency, transparency, and how to protect ICC awards. The use of technology, as the chairman has said, is something that has become a compelling theme after the pandemic and the lockdown. When I started at the ICC a very long time ago as a summer associate, I remember times when trucks would literally pull before the ICC gate and have hundreds of memorials presented to the ICC. And remember, the ICC is neither the tribunal nor a party to the proceedings. But at that time, the ICC required the request for arbitration and the defense to be submitted in hard copies, in as many copies as there are parties to the arbitration. So imagine in complex construction cases, Pamela, you know those construction cases, so you can have tens of subcontractors. The ICC would literally have a truckload of memorials that it will then be expected to ship around. This will no longer be the case under the new 2021 rules, where the ICC has said, request for arbitration, the answer will only be sent to the ICC in electronic copy, even if the arbitrators and the other party were to require paper copy. And I commend that, and I believe that all of us should follow that same approach. And another consequence of the pandemic is increased empowerment of the tribunal to decide, after consulting with the parties, whether a hearing should take place in person or remotely. Now, you have to distinguish between the right of the parties to a hearing, and this is in Article 26.1 of the ICC rules. I'm sure that you all have a copy of the ICC rules next to you. If you don't, please make sure that you download. It's for free, and in all 7 languages that you can think of. So make sure that it's on your bedtime stories before you go to sleep. So when you do open your copy, you will find that in 26.1 of the new rules, any party can ask for a hearing, whereupon the tribunal will order a hearing. And then there's a different and a separate question. Will the hearing happen remotely or in person? I'd like to remind everyone that a remote hearing is a hearing because you talk to each other, you see each other, you can raise a question and you can get an answer, and you can cross-examine the witnesses. So you should not entertain the kind of argument that a remote hearing is not a hearing. I have seen a number of annulment cases raised under the idea that the tribunal has ordered that the hearing should take place remotely when one of the parties required in person. This is rubbish. It should not be entertained, and a hearing shall be ordered by the tribunal as the circumstances of the case warrant, after consulting with the parties, whether remotely or in person. The second theme I wanted to discuss with you is the case of complex arbitration. Now, I can hear some of you saying, and you would be right to say so, I am yet to see one arbitration which is not complex. Well, by complex, what I mean is the case that involves multiple parties or multiple contracts. They have existed forever. 1/3 of the arbitration pending before the ICC involves multiple contracts or multiple parties. Some of the multiple party cases before the ICC involve more than 10 parties. So it is a reality. And the ICC, since the revision of 2012, when it introduced for the first time the rules on multi-party and multi-contract into the rules, have been striving into streamlining the administration of the process. And it seems to me that we have, you see, I'm still using the nominative pronoun, we. It seems to me that the ICC has managed to cross an important threshold in the new revision. And let me address that rapidly. Let's look first at the consolidation that you will find in Article 10. And for the avoidance of doubt, when I talk about consolidation, imagine 2 or more pending arbitration cases before the ICC, and the idea is to bring them into one. An example would be shareholder dispute. So take shareholder A, shareholder B, C, and D, party to a shareholder agreement and party to a share purchase agreement. A brings an arbitration case against B under those agreements. B brings a separate arbitration case before the ICC against C and D. There's obviously a case for consolidation, but until the latest revision of 2021, it required that the consolidated cases would each be commenced in relation to the arbitration agreement in the same agreement. The result of the revision is that now it can be consolidated if the arbitration is coming from arbitration agreements which are compatible with each other. And in the same vein, Article 7 has also crossed an important threshold in terms of the joinder of new parties. Think of construction contracts, where you have cases that would merit to avoid inconsistent decisions, irreconcilable decisions, that where the arbitration is commenced by the contractor against the employer, that guarantors would be involved or subcontractors would be involved as well. Until the latest revision, when the tribunal has already been impaneled, the only possibility to bring in an additional party would be for all the parties to agree on the joinder of the new party. That left many cases where it was impossible to bring a new party, although it made perfect sense to do so. In the amendment to Article 7 now, all that is required after the impanelment of an arbitral tribunal for a party to be joined is that that additional party, not everyone else, that additional party would agree to the constitution of the tribunal and to the terms of preference. Now, that party can agree, but still reserve its right to challenge the jurisdiction of the tribunal. This is possible. It will be the decision of the tribunal, but at least it will no longer be the hostage of everyone's agreement. Moving on to the third theme, and this is about transparency. An important change in Article 17 is a case that has sometimes lent itself to guerrilla tactics. And by guerrilla tactics, I mean some deplorable situations where unnecessary aggressiveness was deployed not to defend one's case, but to thwart the arbitration. A party would change counsel in the middle of the proceedings after the tribunal has been impaneled to create a cause of conflict so that one or more arbitrators would have to step down. This is not acceptable. And the ICC has went as far as one can imagine in changing Article 17 to require, whenever a party contemplates changing of counsel, to immediately so disclose, and ultimately it is the tribunal's empowerment to decide that no change shall be accepted so that we can avoid the creation artificially of a conflict. And that would be a protection of the tribunal. Now, I can hear you, and that was my first reaction when I was brought to discuss that change in a draft form. Doesn't that put in question the sacred right to defense? Am I not entitled to choose my counsel? Yes, you are right. But remember, when you choose to have an ICC arbitration, just like when you want to have an arbitration under QICCA or under the Omani Center for Arbitration, then you refer to the application of the ICC rules. And within the ICC rules, the version of 2021, you have this power of the tribunal that no new counsel will be accepted if the result of the new counsel appointment is to create a conflict. I think it is something that will bring many institutions to follow that. An echo of that transparency is required also in terms of who is behind a party. You are aware, I am sure, that arbitrators have to disclose any reason, any fact that could, in the eyes of the party, raise an issue regarding their independence and their impartiality. This is required, there's no question about that, and when I was sitting on the court, I remember a number of decisions that we took where we realized that an arbitrator had not disclosed in good faith an important element that in the eyes of the parties had created a question. So my advice to all of you present in the room is always err on the side of caution. When you are asking yourself a question, should I disclose or not? Always disclose. If you're disclosing, it means that you believe intimately that you're independent and you're impartial. Because if you're not independent and impartial, you should not stay on the tribunal. You should stand down. So building on that, the ICC requires now a party to disclose as soon as possible who is behind the funding of the case, and by the case it can be the claim or it can be the defense. The presence of a funder can actually cause a conflict, and the arbitrator would not be able to discharge her own disclosure obligation if she were not to know who is behind the party whose name appeared in the case. And this is something that I approve as well. Moving to the fourth theme, rapidly. So fourth and fifth theme, Mr. Chairman, and I'll be rapid about that. Expedited arbitration, great success, which means that we have increased the amount to 3 million, and emergency arbitration provisions is also reinforced. My fifth and last theme is about the protection of the award. In the case of multi-party arbitration, it has always been a challenge where you find, say, amongst the respondents, multiple parties who do not necessarily share the same interest. In a dreadful case in 1990, the .co case, the Court of Cassation in France, the Supreme Court, has annulled an award where 3 respondents, which had obviously antagonistic cases, were required to choose the same arbitrator. And the ICC has since then built a number of solutions. But we were recently confronted, and Sheikh Thani Ben Ali and I were still serving on the court, to a case where the arbitration agreement, so the basis for the arbitration itself, indicated in explicit terms, each party to the arbitration is entitled to nominate an arbitrator. And the case was brought by one claimant against 3 respondents. So claimant had an arbitrator, respondent A had an arbitrator, respondent B had an arbitrator, and respondent C had an arbitrator, and they all elected a president. And the claimant said, well, hang on, I only have one arbitrator, and the respondents, who happen to share the same interest, have 3 arbitrators. So you already have the majority. How can this be the case? And the ICC stepped in. We have discussed this at length at the court, and we decided that in that case, notwithstanding the arbitration agreement, the ICC should get to appoint directly the members of the tribunal. And this is what we indicate in Article 12 of the ICC. It is the ultimate remedy that an institution can take where the institution will go beyond the arbitration agreement to protect the award. And it seems to me that with that, I should bring my remarks to a close by indicating that this new revision of 2021 to the ICC arbitration rules is probably not a revolution. It is a consolidation and an effort in transparency of a body of jurisprudence that is built over the years by the ICC court. Whenever we sit in the ICC court, we take decisions on consolidation. We take decisions on challenges. We take decisions following the scrutiny of the awards. Those decisions and this body of jurisprudence is known to Sheikh Thani Ben Ali, is known to me, is known to other court members, but that is not sufficient. It should be known to all of you. So it is essentially the consolidation of all that jurisprudence which has gone into the new ICC rules. And it seems to me that we should probably avoid any further revision, at least for the next 5 years, so that we can focus on the education and the best use of ICC instead of throwing one more revision. Thank you very much for your attention.
Thank you, Thank you, Dr. Affaki. أما الآن ندعو الأستاذة فاطمة خليفة مستشار قانوني بلجنة قانون التجارة الدولية التابعة للأمم المتحدة يونيسيترال للحديث عن تطوير اليونيسيترال لنظام تسوية المنازعات بين المستثمرين والدول وموجز عن قواعد اليونيسيترال عن التحكيم المعجل لعام 2021.
Thank you very much for the organizers. UNCITRAL is pleased to co-organize this important event. And I will go ahead and deal with my presentation, which is divided into 2 parts. The first one is on the UNCITRAL expedited arbitration rules, and the second part is on the ISDS reform work, or the investor-state dispute settlement reform work of the UNCITRAL. First is the UNCITRAL has been working on the creation of a favorable environment for dispute settlement, arbitration, since the New York Convention and throughout since 1958, which was followed by the UNCITRAL arbitration rules, the UNCITRAL model law, and the amendments on all of them. Also, the UNCITRAL notes on the organization of arbitral proceedings. The latest instrument that the UNCITRAL has worked on is the expedited arbitration rules and the explanatory note thereof, which has been issued and came into force in 2021. I note that Professor Affaki has already covered part of the expedited arbitration rules from an organization perspective, the ICC, so I will try not to repeat as far as possible. So, on the why do we resort to expedited arbitration rules? There has been a need for a simplified and a streamlined procedure for settling international commercial disputes within a short time frame. After all, arbitration has always been promoted as a means of settlement of the disputes that is faster than the courts. And with the practice of arbitration, it has turned out that there are some obstacles to that. So, expedited arbitration rules is needed to preserve again the fast resolution of disputes. Who promulgated these rules? It's the Working Group 2 of the UNCITRAL and the Commission in 2021. When and how do these rules apply? It has to be an express agreement of the parties to resort to such rules, and it applies in conjunction with the UNCITRAL rules on arbitration. And there is a possibility for withdrawal from the application of such rules by one of the parties. And now, what kind of disputes is suitable for the application of the expedited rules? Well, it depends on a number of factors. The first would be the urgency of the matter. If it's urgent, then maybe the expedited arbitration rules is more convenient and more applicable to the dispute at hand. The complexity of the transaction, if it's a more complex transaction, then maybe it's does not fit, but it depends on the parties' agreement. The principle of party autonomy is the principle that applies throughout whatever the rules that we apply. It also depends on the number of parties involved. If we are having a multi-party arbitration, then the likelihood of the multiple of parties agreeing on the expedited rules is minimized. The anticipated complexity and the amount of the dispute. Also, the amount of the dispute plays a factor in the application of such rules. But how expedited are we talking about? Well, the rule says that the final award should be issued within 6 months of the constitution of the tribunal. But is this deadline something that could not be overstepped or could not be increased? The answer is no. There is a possible extension for another 3 months by the tribunal, but if there are further extensions, then the parties' agreement needs to be in place. Of course, the extension needs to be given with an eye on the necessary safeguards to avoid that one of the parties misuse such prerogative or such agreement. So for the parties, it's a shorter time frame for the statement of claim as well as for the respondent's response and the statement of defense. It should also include proposal for the appointing authority and for the arbitrator. If there is no agreement between the parties, then the default rule is the permanent court of arbitration. How to preserve flexibility is an important question. There should be consultations between the parties. There is a discretionary power to the tribunal with regard to time frames, with the hearing, written statements, and evidence. What about technological developments? Discretion to use a wide range of technology to conduct the proceedings is maintained in such rules. How about procedural elements? First, the default rule is a sole arbitrator unless the parties, of course, agree otherwise, and the appointment is by agreement, and there is an increased role of the appointing authority and the simplified designation and appointment process. And the last question is, can the UNCITRAL expedited arbitration rules be applied to investment arbitration? And the answer is, it's left to the parties. So if the parties agree, there is no problem with utilizing such rules in the investment arbitration sphere. And now I move to the second part of my presentation, which is on the investor-state dispute settlement reform. Of course, we cannot talk about a reform if there is not some problems with the system that requires us to make a reform. So the problems that has arisen regarding the investor-state dispute settlement system in investment or investment arbitration, to put it shortly, is the lack of transparency in the system. And why is it important, transparency in investment arbitration? A simple and quick answer is that in investment arbitration, public funds is involved, taxpayers' money is involved, and also the issues that are covered in investment arbitration are different than the issues that are covered under commercial arbitration. But what are the problems or the vices in the ISDS system? There are problems in the arbitral decisions, basically lack of consistency of decisions, coherence, predictability, and correctness of the decisions. Also, other problems are the arbitrators and the decision makers. How the arbitrators are classified as pro-state or pro-investor is a big problem that sheds some challenges to the independence and impartiality of arbitrators in such important proceedings. And finally, one of the other problems is the cost and duration of ISDS. The duration of the investor-state dispute settlement cases is very long, and which entails, of course, additional costs to the parties. So the first reform element is the transparency, and here there are the UNCITRAL transparency rules on treaty-based investor-state arbitration in 2013, which came into effect in April 2014. And it applies in investment treaties concluded on or after that date. And the rules will apply if included in the treaties. But what about the treaties that has been concluded before such date? And here comes the importance of the United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration, or the Transparency Convention of 2014, which is an instrument by which parties to investment treaties concluded before the 1st of April 2014 express their consent to apply the rules on transparency. And finally, we have the Transparency Registry, which is established in 2016, by which the cases that is subject to the transparency rules is available online as an online source for information to the public. So the transparency rules, what is the concept? Basically, a very simplified answer is an increased public information about arbitral proceedings and increased public participation in arbitral proceedings, for example, by the allowing of non-parties or third-party intervention, such as amici curiae, to submit submissions before the tribunal. An important balance needs to be made between different interests: the public interest of the knowledge, the transparency, and the private interest in confidentiality. The Transparency Convention, it applies in a supplemental matter, so it's in relation to all existing investment treaties with respect to transparency-related obligations. And one may ask, but is transparency an absolute rule? Is there no exception to the application of transparency? And the answer is no, because there are still confidential or protected information, even if the transparency rules apply. And this is the transparency registry and the link to it. I think you will have the PowerPoint presentation. So how did UNCITRAL came to deal with the ISDS reform? In 2017, the Commission entrusted Working Group 3 with a broad mandate to work on the possible reform of investor-state dispute settlement. And what are the principles? It's government-led, so it's the governments that leads the process. And it's needless to say that no government is immune from being either having investors that invest in other countries and require the protection of bilateral investment treaties or an international investment instrument, or a state actually itself being a respondent state in investment disputes. So it's very important that all the governments deal with this matter, this is an opportunity that governments actually takes part in this turning point in the ISDS life. It's a high-level involvement. It's fully transparent, and it's, sorry. And it's expertise-led. There could be expertise from the part of the state, not just the officials involved. And it's consensus-based, meaning that the governments have to agree on the contents of the reform at hand. And now, this might be a bit overwhelming because there is a lot on the table of the ISDS reform elements, but let me try to categorize them in three broad topics. The first one would be a prevention topic, which is the alternative dispute resolution mechanisms and dispute prevention. So this is the prevention door, if we may. And it's very important that the alternative dispute resolution or mediation, for example, which is, by the way, there has been the Singapore Convention on mediation, which is a very important tool to recognize the agreements that results from mediation, that both the investors and the states does not deal with the cooling off period or at the beginning of the dispute just by ticking the box, but rather dealing with it in a serious way. Another door is the assistance door, which is the Multilateral Advisory Center as a reform element. And here we have the World Trade Organization example, which has a center on advising on trade issues. Of course, in the ISDS context, it's different, but we still have an example of this. Other reform elements are relating to the selection and appointment of arbitrators in a way that guarantees that there is enough diversity, that there is independence and impartiality. The code of conduct, which is currently under fast-track steps in terms of negotiation, and this is made by it's co-work between the UNCITRAL and the ICSID Secretariat. And the appellate mechanism, as you know, that as matters stand now, that once an investment arbitration award is issued, then it's final, and there is no means to appeal it, even if there are questions of its correctness. So one of the reform options is whether to make an appeal or not of the investment arbitral decisions. Another item is the Multilateral Permanent Investment Court. Should we have a body with fixed adjudicators that are only dedicated to the resolution of investment disputes and does not work as counsel at all, i.e. Avoid what's called double hatting, that the arbitrator today is an arbitrator in an investment dispute, tomorrow he's a counsel, and with all the problems that comes from this system. Another reform element is a multilateral instrument to implement reforms, meaning we have now over 3,000 bilateral investment treaties worldwide. So in order to attempt to modify all these BITs which are existing, it's a very challenging task. So having a multilateral instrument to implement the reforms could be one of the essential elements to make sure that there is a smooth transition of the system to the what we want it to be. And finally, there is the procedural rules reform. And there are many aspects to this that, for the sake of time, I would not cover each. But what is the means to address frivolous or not serious claims? What are the means to address multiple proceedings or parallel proceedings? What about reflective loss in shareholder claims? What about counterclaims? Are states entitled to make counterclaims or not? Security for costs, the regulation of third-party funding, which would be a separate topic tomorrow, the treaty interpretation, and the valuation of damages if we reach that there is jurisdiction of the tribunal and there is liability on the state, and we reach the damages stage or the compensation, which has many rules applying in that sphere, which poses problems about the certainty of the outcome or the predictability of it. So what about now the UNCITRAL has, and I will finish in less than 2 minutes, the ISDS reform. There are initial drafts for comments made by the UNCITRAL Secretariat, which cover multiple issues. First is the initial draft on appellate mechanism. Second is an outline on the cost and financing of a permanent multilateral court. Third is compilation on dispute prevention practices. And finally, there is the pertinent elements of selected permanent international courts and tribunals. All of these drafts, we urge all states to please look at these drafts and provide comments, to attend the working group sessions, and in relation to the attendance of the working group session, there is travel support provided. All you need to do is the delegate from a developing or least developed state request to the permanent mission, to its permanent mission, which then sent to the UNCITRAL Secretariat, and the Secretariat provide travel support to participate in these working group sessions. And as the matters now stand, we are still in a hybrid forum, meaning that there are delegations that attend in person and there are other delegations that join online. And if I may, just on a last note about a colleague mentioned in the previous panel about the court decisions and the importance of sharing them with UNCITRAL, and I really thank him for bringing this point up, because there is the cloud mechanism, which is case law on UNCITRAL text. Basically, there are two ways of having of the information about the important court decisions or arbitral decisions applying UNCITRAL text to be brought to our attention at the UNCITRAL. Either there is a national correspondent for each state, but if there is no national correspondent to say to UNCITRAL, this is an important decision, then please, if you have something on your own initiative, do write to the Secretariat with an abstract of the decision that you think is important, and we will make sure that it's published with due recognition, of course, to you. And that's our contact details, and I thank you very much for your attention.
Thank you very much. نشكر الأستاذة فاطمة على الإيضاحات القيمة على التعديلات الأخيرة على اليونيسيترال رولز. أما الآن ندعو مستر كريستوفر، وهو المستشار القانوني بمركز تحكيم غرفة تجارة ستوكهولم، للحديث عن قواعد مركز التحكيم في غرفة تجارة ستوكهولم. وهو مستشار قانوني عمل لدى العديد من المكاتب الدولية القانونية. So, your floor.
Thank you very much for that introduction. And to start off, I would like to in turn extend my warmest thanks to QICCA for inviting me to this very ambitious and very successful conference. It has truly been a pleasure to be able to listen in on the insightful expert panels and also to visit the beautiful city of Doha. As was mentioned in the introduction, my name is Christopher and I work as a legal counsel at the Arbitration Institute of the Stockholm Chamber of Commerce, in short the SCC. And I have been invited here today to share some spotlights on the SCC rules relating to today's topic. So we'll be speaking about principles and recent amendments in the SCC rules. And let me see. So, and to start off with, and just to contextualize this presentation a bit, I thought that I would mention quickly who we are at the SCC. So the SCC is an arbitral institution that was established in 1917, so a bit more than 100 years ago. Over the years, we have grown into quite an international institution, and this primarily happened during the 1970s and 1980s. And today, we administer about 200 cases per year with parties from around 40 different countries. And at the SCC, we maintain a number of different sets of rules. The primary arbitration rules are the arbitration rules of the SCC, and the rules for expedited arbitrations. The latter is meant for smaller cases and allow for a quicker form of dispute resolution in line with what we have heard during the previous presentations here. Both the arbitration rules and the expedited rules also contains an appendix with provisions for the appointment of an emergency arbitrator to decide on interim relief sought by a party. Under these provisions, the SCC have 24 hours to appoint an arbitrator or emergency arbitrator once the request is received, and the interim decision shall be rendered within 5 working days. Then we have a very new service offered at the SCC, which was launched only last year and that we're very excited about. It is called the Rules for Express Dispute Assessment. In short, in order to make the name a bit easier to say, we call it the SCC Express. And I believe that this particular tool could be of big interest when talking about the topic that is relevant here today. And throughout this presentation, I will be referring to the arbitration rules of the SCC, and we'll come back to the expedited rules and the SCC Express a bit later on. So proceeding then to the first subtopic of this presentation, which is principles. I have listed on this slide what I believe to be the cornerstone principles of the SCC rules, and indeed many arbitral rules, and I think in line with what we have heard today, and also what we heard during the very interesting reveal of QICCA's new rules. We heard that speed and efficiency is an added emphasis and a priority. What I will be talking about, however, is how these principles on this slide are reflected, particularly in the SCC rules. And I believe to frame this discussion, a good starting point to bear in mind is to, when analyzing the function of arbitral institution and the structure and vision of arbitral rules, we must always keep in mind what we as arbitral institutions, as service providers, are able to give to our end users, which are the parties to the dispute. Because the main reasons for choosing arbitration, as we all know, they tend to be the same. The parties want a way to resolve disputes that are quicker than court proceeding, but delivers the same quality of end results, if not better, due to having specialized arbitrators and a more flexible procedure and so forth. So keeping this overarching perspective in mind, the first principles on this slide is efficiency and expeditiousness. And in the SCC rules, we see that these two principles are enshrined in the very beginning of the rules. So Article 2 reads that throughout the proceedings, the SCC, the arbitral tribunal, and the parties shall act in an efficient and expeditious manner. So this is not only an obligation for the tribunal or the parties, but also for the SCC as an institution. Besides this general provision, the SCC rules contains various provisions that are aimed at promoting the efficiency and expeditiousness of the procedure, so be it regarding party submissions or time limits, and also a number of specific mechanisms that can be utilized by the arbitral tribunal to make the arbitral procedure as smooth and efficient as possible. And I will be coming back to some of these more concrete examples later, but before doing so, I will say a few words about what I believe to be the second cornerstone of the SCC rules, and actually for international arbitration as such. Because even though we have talked a lot about expeditiousness and efficiency today, and Even though cost and time efficiency are, of course, of grave importance and very important, especially when it comes to arbitration, the interest of efficiency and expeditiousness must always be balanced against the interest of due process and the rendering of enforceable arbitral awards. Because, of course, the end result that the users of arbitral services seek are enforceable awards, and to be honest, speed and expeditiousness doesn't really matter that much if the result is something other than a high-quality arbitral award that is enforceable and has been preceded by an arbitration where the parties have had a fair opportunity to be heard and to present their case. So, as an expression of this balance that must be struck, we see that it is mentioned in the same Article 2 of the SCC Rules that the tribunal shall make every reasonable effort to render an enforceable arbitral award. A third principle in the SCC Rules that I would like to highlight is what we call a light touch approach to the arbitration. And what does this mean? Well, this means that post-referral of the arbitration to the arbitral tribunal, the role of the SCC becomes smaller. We do still monitor the proceedings and, of course, support the tribunal and the parties who are needed. But in essence, the tribunal enjoys a very wide mandate to manage the arbitral procedure in the way that they deem to be fit. And perhaps different from the two first principles that I have talked a bit about, this is something that might differ between different institutions, especially when it comes to the phase of rendering the arbitral award. So, for example, the SCC does not have any scrutiny of awards, even though we might assist with a formal check. So, having talked a bit about these key principles, I would now like to proceed to mention some concrete examples on how these principles are embodied in the SCC Rules. And most of the rules on this slide were actually introduced in 2017, where the arbitration rules and the expedited rules were revised, and this is the latest rule revision of the SCC. And one of the explicit main purposes of this rule revision in 2017 was to improve the efficiency of the proceedings. And I believe that this is also the way that the SCC, as well as many other arbitral institutions, will continue to go, and that this will be necessary to meet the evolving needs and demands for expeditiousness and efficiency of our users. Because in general, I quite believe that this is a general trend that we can see, that in international dispute resolution overall, the parties are asking for more cost and time efficiency. And this is perhaps due to many industries evolving and business model being more agile and efficient themselves. So I believe also that this is a trend that arbitral institutions in the future will have to work to really adapt to. So proceeding to the concrete examples, the first example are provisions for greater flexibility in multi-party disputes, similar to the provisions that we heard about in the ICC rules. Because in the 2017 revision of the SCC rules, provisions allowing for the joinder of a third party to an arbitration, the adjudication of claims under multiple principal contracts, and also consolidation of multiple SCC arbitrations were introduced. It can be noted that these decisions are all taken by the SCC board, and as far as joinder and multiple claims are concerned, it is explicitly set out in the rules that in doing so, the SCC board shall consider the efficiency and expeditiousness of the arbitral procedure. The second example that also was changed in the 2017 revision of the rules is that the default rule saying that if the parties had not agreed, the tribunal should consist of 3 arbitrators was removed. So today, if there is no party agreement on the number of arbitrators, it is for the SCC board to decide whether the tribunal shall consist of 1 or 3 arbitrators, and this will of course depend on the complexity of the dispute, the amount in dispute, and the amount of evidence put forth by the parties and so forth. And of course the aim here as well was to increase the efficiency of proceedings, and both meaning cost and time efficiency were applicable and appropriate. The third example that I wanted to highlight is the tool called summary procedure. And this was basically introduced in order to make it possible for the tribunal to adjudicate isolated issues in arbitrations in a streamlined and efficient manner. So summary procedure allows the tribunal to decide on issues of fact or law. Most commonly, this will perhaps concern jurisdiction or admissibility without taking all the necessary steps that are usually taken for procedural decisions in an arbitration. And in order to, I know it's getting a bit late in the afternoon, so I won't mention all the criteria set out in this article, but suffice it to say that in essence, they all come down to the tribunal weighing the interest of efficiency against the interest of due process. So once again, this balancing of principles that I talked about initially. The final example that I wanted to mention is that when the SCC determines the final costs of the arbitration, meaning the fees of the arbitral tribunal and the administrative fee of the SCC, the SCC shall consider the efficiency and expeditiousness of the work of the arbitral tribunal. So the point of this is, of course, to create an incentive for the tribunal to adhere to these principles, thereby creating a practical application of the underlying principle of efficiency and expeditiousness. In turn, the same incentive is created for the parties, because if requested by a party, the tribunal shall apportion the costs, the party costs, so predominantly counsel fees, between the parties having regard to the outcome of the case as well as the conduct of the parties. So, my presentation so far has focused on the arbitration rules primarily, and I will now say a few words about the expedited rules. And the expedited rules were drafted in 1998, and when they arrived, they were perhaps a bit thought-provoking, but today they have gained a very strong foothold in the caseload of the SCC. In fact, in 2021, they applied to 30% of our cases, so I think that this is another example of how we can see that the users of arbitral services are really interested in finding new ways to make their dispute resolution more efficient and perhaps even expedited. And as I mentioned initially, the main idea of the expedited rules is to allow for a quicker arbitral procedure aimed at smaller cases, and for this reason, the expedited cases are always adjudicated by one arbitrator. And the rules also provide for a front-loading of the case, which means that the request for arbitration also serves as the statement of claim, and that the answer to the request for arbitration also serves as the statement of defense. So what does this mean in principle? Well, it means that if the parties have already submitted their main submissions on the merits, they basically only need to submit perhaps one more submission once the case has been referred, which will, of course, make the final award possible to render quickly. And this is also reflected in the time limit available to the arbitral tribunal to render the final award under the expedited rules. This is 3 months as opposed to the 6-month limit under the arbitration rules. And also the standard for holding a hearing is higher under the expedited rules, so the parties will have to present more convincing arguments for the tribunal to decide, or the arbitrator to decide to hold a hearing. Something that we sometimes see, once again, balancing efficiency and expeditiousness, is that the parties might have agreed to an application of the expedited rules when in fact it is clear on the outset of the dispute that it is more appropriate to apply the arbitration rules. What the Secretariat can do in those cases is that we can invite the parties to a rule swap, so swapping the expedited rules with the arbitration rules, but this, of course, requires the agreement of the parties. So, as you've heard throughout this presentation, I have been focusing quite a lot on the value of efficiency and the increasing demand from the users of arbitral services for expedited and efficient procedures. And as mentioned, I do believe that this really is a big challenge for arbitral institutions, and it will be a big challenge in the future to really adapt our services to this need. And what we tried to do last year at the SCC is that we tried to meet this demand by introducing a completely new set of rules, and that is the SCC Express. And the SCC Express is completely freestanding from the arbitration rules and the expedited rules. And basically it allows for the parties to get a legal assessment of a certain issue or a smaller dispute from a neutral assessor at a fixed fee. And the end result, as opposed to arbitration, is findings. So the findings are delivered by the neutral, and these findings shall be delivered within 3 weeks from the referral of the case to the neutral. The SCC Express was designed to fill a gap, really, where the parties perhaps had some degree of agreement as between them, but had one issue of factor law that were prohibiting them from continuing in their business relationship. And to sort of sum up this presentation, I believe that innovations like the SCC Express, whether it be in separate instruments or innovations in the spirit of meeting the demands of our users in arbitral rules, will be a necessity for arbitral institutions going forward in order to stay the attractive dispute resolution alternative that we are today. And with that, I conclude my presentation, and thank you very much for your time and attention.
Thank you very much, Mr. Christopher, for the valuable insight on SCC system. أما الآن ننتقل مع المتحدثة الأخيرة الدكتورة منى المرزوقي، وهي عميدة كلية القانون في جامعة قطر بالإنابة، وقاضية في محكمة قطر الدولية، وحاصلة على الدكتوراه في القانون البحري.
شكراً أستاذ فيصل. بسم الله الرحمن الرحيم. سعادة الدكتور ثاني بن علي آل ثاني، عضو مجلس إدارة مركز قطر الدولي للتوفيق والتحكيم، السادة الحضور، السلام عليكم ورحمة الله وبركاته. يطيب لي في مستهل حديثي اليوم عن دور مركز قطر الدولي للتوفيق والتحكيم ودور محكمة قطر الدولية فيما يتعلق بالتحكيم أن أتقدم بالشكر الجزيل للمركز وعلى رأسهم الدكتور ثاني على دعوتهم الكريمة والسماح لنا بالمشاركة في هذا المؤتمر مع نخبة من المتحدثين في مجال التحكيم. في كل يوم تطرق دولة قطر باباً من أبواب التطور والحداثة، وكان للتشريعات والنظم والقواعد عامة نصيباً ليس باليسير منها، ومن بينها القواعد الحاكمة للتحكيم، إذ كان لها نصيب من ذلك التطور التشريعي المواكب لضرورات سرعة إنجاز المعاملات التجارية والمدنية وتحفيز الاستثمار الوطني والأجنبي وتعزيز مناخه ودفع عجلة التنمية الاقتصادية وإيجاد حلول سريعة للقضايا التي تنشأ بين القطاعات المختلفة الداخلية منها والخارجية. فكان ميلاد القانون رقم 2 والخاص بالتحكيم في العام 2017، وقد سبقته في الوجود النصوص المنظمة للتحكيم في قانون المرافعات المدنية والتجارية للعام 1990 والتي ألغاها قانون التحكيم الساري. وقد حرصت الدولة على إنشاء هيئة أو كيان يؤكد ويعزز مكانة دولة قطر كموقع عالمي رائد للمال والأعمال، معد لاستقطاب أعمال البنوك العالمية والخدمات المالية وأنشطة التأمين والمراكز الرئيسية للشركات وغير ذلك من الأعمال. لذلك صدر القانون رقم 7 لسنة 2005 لمركز قطر للمال وإنشاء هيئة تديره يكون لها من الاختصاصات والمهام بما يتوافق ورؤية المشرع. وكان لزاماً في ظل وجود هذا المركز إنشاء جهة قضائية تقوم بالفصل في المنازعات بين الشركات المؤسسة بموجب قوانين مركز قطر للمال أو بين تلك الشركات والأفراد والشركات الأخرى في الدولة المؤسسة بموجب قانون الشركات القطري. إذ نصت المادة 8 من قانون مركز قطر للمال رقم 7 لسنة 2005 على إنشاء محكمة تابعة للمركز تسمى محكمة قطر الدولية، وأعطاها الاختصاص الذي ذكرناه سابقاً بالإضافة إلى أي اختصاص آخر ينص عليه قانون آخر كالنظر في منازعات التحكيم وأيضاً منازعات المناطق الحرة. ثم كان العام 2006 حيث أنشئ مركز قطر الدولي للتوفيق والتحكيم التابع لغرفة تجارة وصناعة قطر، واستحدثت قواعده المتماشية مع أحدث الممارسات التحكيمية الدولية ومع القواعد النموذجية المعدة من قبل لجنة الأمم المتحدة للقانون التجاري الدولي اليونيسترال. وكان الهدف الرئيس من وراء إنشاء هذا المركز هو أن تكون هناك وسيلة سريعة لحسم النزاعات التي تدور بين أفراد القطاع الخاص الطبيعيين أو المعنويين مع غيرهم. ويسعدنا تهنئة المركز على صدور قواعده الجديدة في هذا اليوم. من هذه المقدمة نجد أن هناك كيانين قانونيين كبيرين مختصين رائدين في دنيا المال والأعمال داخل دولة قطر، يتحتم علينا ذكر الفروقات بينهما وتوضيح أي لبس قد يحصل في دور كل منهما، ألا وهما مركز قطر الدولي للتوفيق والتحكيم وقواعد التحكيم الخاصة به من جهة، ومحكمة قطر الدولية التابعة لمركز قطر للمال، ولائحة التحكيم رقم 8 لسنة 2005 الخاصة بهذا المركز من جهة أخرى. بالنسبة لمحكمة قطر الدولية ودورها في التحكيم واختلافها عن مركز قطر الدولي للتوفيق والتحكيم، فإننا نود توضيح التالي: تمارس المحكمة الصلاحيات المخولة إليها بموجب أحكام القانون رقم 2 لسنة 2017 بإصدار قانون التحكيم في المواد المدنية والتجارية، إذ عرفت المادة الأولى من القانون المحكمة المختصة بأنها دائرة منازعات التحكيم المدني والتجاري بمحكمة الاستئناف أو الدائرة الابتدائية بالمحكمة المدنية والتجارية لمركز قطر للمال بناء على اتفاق الأطراف. وبطبيعة الحال هذا الاختصاص منوط بالنظر في المسائل الإجرائية الخاصة بالتحكيم. أما بالنسبة للقاضي المختص فقد عرفته ذات المادة من قانون التحكيم القطري بأنه قاضي التنفيذ بالمحكمة الابتدائية أو قاضي التنفيذ بالمحكمة المدنية والتجارية لمركز قطر للمال إذا اتفق الأطراف على ذلك. وفي هذه الحالة يختص هذا القاضي في تنفيذ أحكام التحكيم التي تعرض عليه. بالتالي إذا اختيرت محكمة قطر الدولية من قبل أطراف التحكيم لتكون المحكمة المختصة، سيكون اختصاصها منحصراً في الفصل في منازعات التحكيم إذا اختلف الأطراف على أي من إجراءات التحكيم، إلى جانب اختصاصها الرقابي بنظر دعوى بطلان حكم التحكيم. وتطلع الدائرة المدنية والتجارية بمحكمة قطر الدولية بهذا الاختصاص. أما بالنسبة لتنفيذ حكم التحكيم، وفي حال اتفاق الأطراف يمكن أن يكون القاضي المختص هو قاضي التنفيذ بمحكمة قطر الدولية. إذن الأصل إذا كان مقر التحكيم دولة قطر أن تختص المحاكم الوطنية في الدولة للنظر في منازعات التحكيم أو تنفيذ حكم التحكيم، كما رأينا إذا كانت هي دائرة منازعات التحكيم المدني والتجاري بمحكمة الاستئناف أو الدائرة المدنية والتجارية التابعة لمحكمة قطر الدولية. فإذا اتفق الأطراف صراحة بانعقاد الاختصاص لمحكمة قطر الدولية، فيكون الاختصاص لهذه المحكمة طالما ذهبت إرادة الأطراف صراحة إلى اختيار المحكمة كمحكمة اختصاص في مسائل التحكيم. وتوفر المحكمة شرطاً نموذجياً للتحكيم ليتمكن أطراف التعاقد من إدراجه في تعاقداتهم. والنص جاء على النحو التالي: عنوان النص: بند تسوية المنازعات في محكمة قطر الدولية ومركز تسوية المنازعات. أما فحوى النص فهو مقتبس طبعاً: تتم إحالة أي نزاع ينشأ عن هذا العقد أو فيما يتعلق به بما في ذلك أي سؤال يتعلق بوجوده أو صلاحيته أو إنهائه إلى التحكيم، أو تتم في نهاية المطاف تسويته بواسطة التحكيم الذي يتم من قبل، طبعاً هنا يدرج اسم مركز التحكيم، فيما يتوافق مع، وهنا يتم إدخال اسم قواعد التحكيم السارية في وقت تقديم طلب التحكيم. وأدرجت هذه القواعد في هذا البند بالإشارة. تعتبر قطر مقر التحكيم. تتألف هيئة التحكيم من يدرج هنا طبعا عدد المحكمين من المحكمين. يتم اعتماد اللغة، وتختار هنا طبعا اللغة في التحكيم. تعتبر المحكمة المختصة للتحكيم الدائرة الابتدائية للمحكمة المدنية والتجارية لمركز قطر للمال. وفي حال التنفيذ يكون القاضي المختص هو قاضي التنفيذ في الدائرة المدنية والتجارية لمركز قطر للمال. انتهى الاقتباس. يقتصر دور المحكمة على الإجراءات التي يختلف عليها الأطراف فقط عند لجوءهم إلى التحكيم، وتحتاج طبعاً إلى فصل حاسم حتى تنقضي المسألة وتستكمل إجراءات التحكيم، كطلبات تعيين المحكمين وتنحيتهم، والبت في الطعون المقدمة ضد الاختصاص القضائي، وتقديم المساعدة في الحصول على الأدلة، وتصحيح القرارات، والنظر في طلبات الاستئناف التي يتم رفعها ضد القرارات، وكذلك البت في الطعون المقدمة لها ضد قرارات التنفيذ. علاوة على ذلك ينظر قاضي التنفيذ الخاص بمحكمة قطر للمال في الطلبات المتعلقة بالتدابير المؤقتة وتنفيذها، وتنفيذ القرارات الصادرة من الدائرة الاستئنافية لمحكمة قطر للمال. وحري بالبيان أن الأطراف من الشركات أو المؤسسات أو الكيانات حال كونها غير مؤسسة ومسجلة بموجب قوانين مركز قطر للمال واتفقوا على جعل الاختصاص لمحكمة قطر للمال، فإن المحكمة في هذه الحالة ستطبق نصوص قانون التحكيم القطري رقم 2 لسنة 2017. أما إذا كان الأطراف كلاهما أو أحدهما مسجلين في مركز قطر للمال وذهبت إرادتهم إلى منح محكمة قطر الدولية الاختصاص بمنازعات التحكيم، ففي هذه الحالة تطبق لوائح التحكيم الخاصة بمركز قطر للمال رقم 8 لسنة 2005 الخاصة بالتحكيم طبعاً، والتي جاءت على 8 أبواب و4 أجزاء مفصلة شاملة لجميع ما يمكن أن يكون محل اعتبار في عمل هيئة التحكيم وتعيينها ونظرها للمسائل الوقتية والمستعجلة وإلى غير ذلك. وتتشابه هذه اللائحة في جوهرها وأهدافها مع قانون التحكيم القطري رقم 2 لسنة 2017 إلى حد كبير جدا. فبالتالي فإن محكمة قطر الدولية ليست مركزاً للتحكيم الحر أو المؤسسي، وليس لديها قواعد تفصيلية لإجراءات التحكيم أو محكمين ليقوموا بالفصل في منازعات ليقوموا بعملية التحكيم، كما هو الحال في مركز قطر الدولي للتوفيق والتحكيم الذي يختص بشكل أساسي في فض المنازعات عن طريق التحكيم. بالتالي يكون دور محكمة قطر الدولية مكملاً لدور مركز قطر الدولي للتوفيق والتحكيم، والتي نظمت مسائل التحكيم في مواد تفصيلية. فإذا ما اختلف الأطراف على أي من إجراءات التحكيم تلك واختاروا بإرادتهم اللجوء إلى محكمة قطر الدولية، فإن المحكمة في تلك الحالة ستكون جهة الاختصاص في فض أي نزاع تحكيمي أو في تنفيذ حكم التحكيم، وستطبق المحكمة القواعد الإجرائية الخاصة بها لرفع الدعاوى وتقديم الطلبات أمامها. وهذه الإجراءات مبنية على النظام الأنجلو ساكسوني، وتعتمد المحكمة نظام إدارة القضايا الذي يديره رئيس قلم كتاب المحكمة. ومن ضمن إجراءات رفع الدعوى أمام هذه المحكمة أن تكون جميع المذكرات والمستندات الداعمة مسلمة للمحكمة من قبل طرفي النزاع قبل عقد أي جلسة، والاستماع إلى المرافعة الشفوية من قبل طرفي النزاع. وتقدم الطلبات وتعقد الجلسات في هذه المحكمة باللغة الإنجليزية، ولكن حسب قوانينها يمكن للأطراف في حال رغبتهم تقديم المستندات وتقديم مرافعتهم الشفوية باللغة العربية أن يقوموا بذلك، وتتوفر الترجمة الفورية للقضاة في هذه الحالة. ويعمل قلم كتاب المحكمة على توفير الدعم والمساندة اللازمتين لأطراف الدعوة قبل تقديم أي طلب للمحكمة وصولاً إلى إصدار حكم. هذا باختصار شديد أهم الفروقات بين مركز قطر الدولي للتوفيق والتحكيم ومحكمة قطر الدولية فيما يتعلق بالتحكيم، آملين أن يكون ما ذكرناه ذا فائدة ترجى، وتفضلوا بقبول وافر من الاحترام والتقدير. السلام عليكم ورحمة الله وبركاته.
شكرا دكتورة منى على هذه الإيضاحات فيما يخص العوامل المشتركة والفروقات بين محكمة قطر الدولية ومركز قطر الدولي للتوفيق والتحكيم، واللي حقيقة كثير من المختصين يحدث لهم لبس في هذا الشأن. في الختام لا يسعني إلا أن أقدم الشكر للمتحدثين الكرام، ونعيد الشكر أيضا للمنظمين على رأسهم سعادة الشيخ ثاني بن علي على هذه الدعوة الكريمة والتنظيم الرائع، متمنين لهم موفور الصحة والتوفيق الدائم. شكرا جزيلا.
جزيل الشكر والتقدير للسادة المتحدثين والسيد رئيس الجلسة. نطلب منكم التكرم بالبقاء على المنصة لحين التكريم من الأستاذ يوسف الزمان. إذا تكرمت أستاذ يوسف عضو لجنة التوفيق والتحكيم
نعم.
بالمركز.
احنا بس إذا تأذن لي ما أعرف إذا كان عندنا وقت حق الأسئلة ولا أنا توقعت بعد أنه يكون كيف. الله يسلمك.
نعم.
إذا أسئلة الله يسلمك احنا نتشرف ناخذ منك أول سؤال، إذا بيكون سؤال أو سؤالين بالكثير. معنا الأستاذ يوسف.
أتوجه بسؤالي للدكتور جورج أفاقي. بداية أشكر الدكتور على تقديمه المفيد للقواعد المقررة التي أدخلت على قواعد الICC، وأود أن أوجه لسعادته السؤال التالي: بالنظر إلى عدم وجود سلطة الإجبار لدى هيئة التحكيم كما هو معروف، وخضوع العملية التحكيمية لإشراف القضاء، خاصة تلك المتعلقة بتنفيذ قرارات وأحكام المحكمين، إلى أي مدى تكون فاعلية ونجاعة التعديلات التي أدخلت على قواعد غرفة التجارة الدولية، هذه التعديلات الحديثة التي عرضتم لها؟ وهل تكفي إرادة الطرفين في ذلك؟ هذا بالنسبة للسؤال الدكتور أفاقي. أيضا سؤال الأستاذ كريستوفر بخصوص التحكيم المعجل الذي تطبقه غرفة تجارة ستوكهولم، خاصة بما ورد بالتحكيم المعجل باقتصار مدة التنفيذ مدة التحكيم ل6 أشهر أو حسب ما أنا فهمت. ما مدى تقييمك لهذه القاعدة؟ وفي حالة ما إذا تجاوز المحكم أو هيئة التحكيم هذه المدة، ما هو الجزاء الذي يترتب على ذلك؟ وشكراً.
شكرا للزميل الأستاذ يوسف على سؤاله الوجيه. إذا ممكن سيادة الرئيس أجاوب عليه. زميلي العزيز، طبعا سؤالك الوجيه يمكن أن يطبق على كافة الإجراءات التحكيمية الموجودة تحت ولاية أي مؤسسة، سواء كانت مركز قطر، مركز السويد أو مركز الICC. برأيي يجب أن نفرق بين مرحلتين من مراحل الإجراءات التحكيمية. أولاً، المرحلة التي يكون فيها لهيئة التحكيم ولاية. في هذه الحالة الولاية محصورة بهيئة التحكيم، كافة الأمور الإجرائية يختص بها المحكمون ولا غير ولا شخص آخر. فاللجوء للقضاء في هذه الحالة يجب أن يكون استثنائي، إما على طلب هيئة التحكيم إذا أرادوا أن يمدوا ولايتهم إلى شخص ثالث، مثلا شاهد، ففي هذه الحالة يكون القضاء سيف بيد هيئة التحكيم ليمكنهم من مد ولايتهم، أو بعد انتهاء ولاية هيئة التحكيم بإصدار الحكم النهائي، ففي هذه الحالة تصبح ولاية القضاء كدرع يقي إجراءات التحكيم ما لم يشيبها عيب، ونعرف أن هذه العيوب هي يجب أن تفسر بشكل مقتضب، وإلا سيتم المس بحرمة التحكيم. فجواباً على سؤالك، الهدف من تعديل إجراءات غرفة التجارة الدولية هي مد الأطراف ومد المحكمين بكافة الأساليب اللازمة لإنجاح عملية التحكيم، لأن اللجوء للقضاء يجب أن يبقى استثنائي. إذا نظرت إلى الإحصاءات التي نعدها في عمليات التحكيم الدولي، نجد أن الأغلبية الساحقة لعمليات التحكيم تنتهي إلى قرارات نهائية يتم تنفيذها طوعاً وليس أمام القضاء. وحين تنتهي الأمور أمام القضاء فمن النادر إذا كان القاضي نزيها وكان القاضي يحترم حرمة التحكيم، من النادر أن نجد قاضي يمس بحكم التحكيم ما لم يشيبه عيب من العيوب المقيدة حصرا في المادة 5 من اتفاقية نيويورك، والتي تم تطبيقها في القوانين 169 دولة التي صدقت على نيويورك. فلذلك جوابي باختصار هو أن التعديلات استهدفت المحكمين والأطراف أولاً وليس القضاء، لأن تدخل القضاء يجب أن يكون استثنائياً في عمليات التحكيم. وشكراً على سؤالك.
Second question was directed to Mr. Christopher regarding the expedited arbitration.
Yes, and thank you very much. I'm just going to take this off. Thank you very much for your question, Doctor. I think the first question related to the enforcement of awards under the expedited rules, and of course this comes back to the time limit, both the 3-month rule and the 6-month rule under the arbitration rules. And it is of course important that that time is kept, because otherwise it could be seen as an excess of mandate, which would of course risk the enforceability of the award. So for this reason, there is a possibility for the Secretariat to prolong the time for rendering the arbitral award. And this can be done upon a recent request by the arbitrator or arbitral tribunal, or with the consent of the parties. So when it comes down to the second part of the question, how this looks in practice, then we see under the arbitration rules that the majority of the awards are rendered within 12 months, with a bit fewer rendered within 6 months. And for the expedited rules, I think last year about 60% of the awards were rendered within the 3-month limit. So this, of course, reflects the reality that these time limits cannot be kept in all cases. I mean, especially in complex cases where it would risk the due process interest of the parties to sort of prioritize the efficiency to the degree that we would say that these time limits are absolute. But with that having said, it's not an automatic right to renewal, but rather it is requires a party agreement or good reasons from the arbitrator or the tribunal. I hope that this answers the question.
Thank you very much.
Thank you.
I think we can have one more question. آخر سؤال بس إذا بتسمحوا لنا، أشوف كان حد من الشباب.
If there's no question, maybe I can have a question, Mr. Chairman. Can I? My question to Christopher, if I may. And the SCC, I'm a big fan of the SCC, Christopher. You have always been a laboratory of innovation in arbitration. You were the first who gave shape to the concept of emergency arbitration in 2010, and now it became a standard. And I'm intrigued in your SCC Express. I remember in my youth when the first episode of Superman was unleashed, the question was, is it a bird? Is it a plane? No, it's Superman. So my question to you is, what kind of proceeding is the SCC Express? Is it arbitration? You obviously are saying no, because it's not binding. So is it not simply a form of expert determination? And if this is the case, what's new, Christopher?
In 2 minutes, please.
In 2 minutes, now can I hear? Thank you very much for that question. That is certainly very interesting. And to sort of go back to the first part of it, it is indeed, to use a term that I heard previously today and which I liked quite a lot, I think it was a creature of contract. So it is consent-based, and it is based on the parties having agreed to the SCC Express, but also, I would say, it will be most useful in situations where the parties also have some sort of agreement and therefore no need for a binding and enforceable decision. So this would be something that we have envisaged a few scenarios. We were thinking that it could be useful if the parties are, for example, engaged in settlement negotiations, but they have a specific legal matter that they just cannot push through. And this could also be the case in contract negotiations, or basically what the parties wanted to be. So to answer the first part of your question, what is the SCC Express? The answer in a big extent is what the parties need and what the parties want it to be. So as I said, the end result, the findings of the neutral, they are not binding by default, but the parties can agree to make it contractually binding. They can also agree that the tribunal shall basically convert the findings to an arbitral award. But we see the main case being a case where there is no need for an enforceable decision. And then to go to the second part of the question, you asked what's new, how does it differ from expert determination? And I would say that, we have developed a completely new set of rules where there's actually a procedure set out for how these proceedings shall be handled, what the mandate of the neutral is. There is a fixed fee, there's a time limit set to it, so we believe that this can really make a difference and make it easier for parties to go through the obstacles that they might face commercially and legally. I hope that was an answer. Thank you.
Thank you again.
شكرا جزيل الشكر والتقدير للسادة المشاركين في الجلسة لما قدموه. تفضل الأستاذ يوسف مشكورا للتكريم. الأستاذ فيصل السحوتي رئيس محكمة قطر، شكرا والتقدير. بروفيسور جورج تفضل مشكورا. تكريم الأستاذ الدكتور جورج أفاقي. الأستاذة فاطمة خليفة فلتتفضل مشكورة. Mr. Christopher, please. سعادة الدكتورة منى تفضلي من فضلك كريم. شكرا جزيلا لحضراتكم. شكرا. الآن ننتقل إلى الجلسة التالية مباشرة. الجلسة التالية بإدارة المهندس محمد الكواري. تفضل مشكورا مستر جيمس. تفضل قول لي. نعم الأستاذ الدكتور نادر محمد إبراهيم فليتفضل مشكورا معنا. مستر جيمس بريدجمان بليز كم. تبدأ كده أنا بس أوضح نقطة للسادة الحضور. إحنا إن شاء الله في الجلسة لن نتأخر أكثر من نصف ساعة الأخيرة، فنلتمس منكم الاستمرار معنا في الجلسة إن شاء الله لحين الانتهاء بما يعود بالنفع على الجميع بمشيئة الله. الدكتور أحمد سيد تفضل دكتور بفضلك.